It is my pleasure to introduce Julie Jonas as our presenter today. Julie Jonas is the legal director for the Innocence Project of Minnesota. She's worked for the Innocence Project since 2003. In addition to her work for the project, she teaches at Minnesota law schools, where her focus is on prevention of wrongful convictions and working with clinical students to screen and investigate cases of potential innocence. Jonas completed her undergraduate and law degrees at the University of Minnesota. After law school, she practiced with the Ramsey County Public Defender's Office in St. Paul, Minnesota. Welcome, Julie. The floor is yours.
Thanks, Michelle. Thanks so much for having me. Hi, everyone. One other thing that might be fun to note in my bio for this group is that I live in Golden Valley. So
all right, good.
It was one of the reasons when we were contacted at my office, I said, oh, I'll do that. It's where I live. And then I thought, well, it's going to be on Zoom anyhow. But nonetheless, it's still good. So thank you so much for having me. I'm going to spend pretty much all my time with a PowerPoint so you can see some pictures of our clients. So I'm going to put that up and then I'll come back at the end and we'll have time for questions at the end. Michelle told me that you're a pretty talkative group, so I'll make sure to wrap up the PowerPoint by like 1 or 1:05, so we'll have some time to talk, okay? Let me share my screen. Wait, okay. Sure that's good. Okay, now everyone should, oh, wait, bring that over there. Yeah, I know you guys can see it. I've got to get my notes page up though too. Oh crap, that was working a second ago. Okay, okay,
good. To change your view at the top right corner, there's
no, I've got it. So you guys are seeing one slide that says the Innocence Project founded in 1992, right?
Correct.
Okay,
Correct.
All right, so good. So the Innocence Project, many of you, obviously some of you are here particularly to hear more about it, but I think all of you have heard about it. Founded in 1992 by Barry Scheck and Peter Neufeld. They were the first people to have the idea that DNA testing could be used to prove innocence. Law enforcement was already in the 80s starting to use DNA testing to prove guilt. So biological fluids left behind at a crime scene, typically a rape or a murder where you might find blood or sperm or semen left behind. Law enforcement was using DNA testing to test that to help prove that someone was guilty. Scheck and Neufeld had the idea that maybe you could find that if law enforcement or the hospital or the medical examiner's office had kept that same biological fluid on older cases where the person was sent to prison before DNA testing was available, if it could be found and tested, you could prove, in fact, that the person in prison was innocent. And they were really successful with that. So far, there's been over 360 DNA exonerations, which has resulted in organizations all across this country and around the world doing similar work under the umbrella of something called the Innocence Network. So we're all affiliated together. I've gotten this slide over 60 because I can't keep up with this slide. I think now we're at 66, again, across the United States, but also in Asia, Central and South America, Europe. It's a really growing movement all exonerating people. In Minnesota, our mission is threefold. One is to keep innocent people from being convicted in the first place. So we do a lot of policy work up at the legislature. And so I'll talk to you a little bit about that kind of work that we do. We also want to unite as many groups as possible to fix the flaws in our system and educate people about the possibility of wrongful convictions, which is why I'm here today talking to you. And then, of course, to free people who are in prison for crimes that they did not commit. One of the things that was fascinating coming out of the DNA movement is that it was really just the start for this whole innocence movement, because of course, most serious felony cases don't involve DNA at all, right? If you think about a drive-by shooting or a robbery or the vast majority of other types of felonies that just don't involve DNA. But because we saw all these people being exonerated through DNA testing, there was really a movement in the criminal justice system to A, look beyond the boundaries of DNA, and B, look at what was going wrong with our system, why people were being wrongfully incarcerated in the first place. And this slide comes from an amazing group. If any of you are interested in more particulars about my talk here today, there's a wonderful group of people putting together the Exoneration Registry. And I didn't put up the URL because it's kind of long, but if you just type into Google Exoneration Registry, you will get there. And they have tracked all exonerations from the country, not just DNA exoneration. So you can see when this slide was put up just the beginning of this month, there were 2,674 total exonerations around the country. That included the 360 some DNA exonerations. The other thing that they've really been good about doing, besides tracking all of these exonerations, categorizing them, telling the stories of the exonerees, is determining what the common causes of wrongful convictions were. Because you can look at these cases and determine, sort of post-exoneration, what were the problems? Why was the person falsely incarcerated in the first place? And you can see the #1 cause is that red bar, perjury or false accusations, almost 60%. The second largest cause is official misconduct. That encompasses both police misconduct and prosecutorial misconduct at just over 50%. Mistaken eyewitness identification comes in just under 30%. And what's interesting about that is if you look at just the DNA exoneration, so just those 360 some cases, in those cases, mistaken eyewitness identification is the #1 cause. And there's a reason why it's so much higher in just looking at those cases. Most of those cases did in fact involve stranger rape cases where a woman was raped and it was a stranger and she went immediately to the hospital. A rape kit was taken so that DNA was preserved, available and preserved. And because it was a stranger rape situation, it's much more likely for a mistaken eyewitness identification to be made than in other standard wrongful convictions. You can also see false confessions are a factor. In just over 10% of the cases, a person falsely confessed to a crime they didn't do. And in about 10% of the total cases, somebody pled guilty to a crime that they didn't do. And then false or misleading forensic testimony in just over 20% of the cases. So for the rest of my talk, what I'm going to do is really focus on Minnesota cases and how they illustrate each of these different types of reasons for wrongful convictions. So the first one I want to talk about, the largest cause, is perjury or false accusations. And that is illustrated so well in the case of my good friend Sherman Townsend. He was the first man that we were able to get out of prison here in Minnesota. And what had happened in Sherman's case was that a young woman and her boyfriend were asleep in this house. This house is in Minneapolis in Dinkytown by the University of Minnesota. A woman and her boyfriend were asleep in the upstairs bedroom. They woke up in the middle of the night to find an intruder on top of them in their bed. The intruder fled. No one was injured. Nothing was taken. But of course, they called law enforcement. The police came and began searching outside the building for clues. The woman and her boyfriend could not give much of a description. They said they believed it was an African-American male, but it was very quick. It was dark. They had been sleeping. While law enforcement was looking around, they were approached by a neighbor. There's an apartment building next door to this home. The neighbor came over to ask the police officers what was up. The police officer said that there had been a break-in at this home and had he seen anything? And he said, well, yes, he had just been coming home from the bar and he was opening the exterior door to his building, the security door, and somebody came running from this house and knocked him over. The police asked if he could give a description. He did, and it was a fairly general description. African-American male, average age, average build, average height, right? Not a lot wearing shorts and a t-shirt, but it was August, so that was not peculiar either. So police put out this description. A different squad car in the area saw Sherman walking down the road and asked him to come over and talk to them, asked for his name. And Sherman was a very good suspect because he did have a history of burglaries. But he had been out for a walk and had just simply bought a pack of cigarettes. The police actually confirmed that he had just been to the gas station just a few blocks away and purchased cigarettes. But police still believed he would have had enough time to break into the home, run and purchase the cigarettes, and then get to the point where they had picked him up. So it wasn't enough of an alibi. So police brought him back to the scene to show him to the witnesses. This is called a show-up identification. As you can imagine, it's incredibly biasing. There's no other fillers as you would have in a typical photo array or even a live lineup at a police department, one person is taken back to the scene of the crime in the squad car, sometimes in handcuffs, obviously a very biasing situation. The neighbor said, yes, that's the guy. That's the guy who hit me and knocked me over. The victims were not certain, but said it could be the guy. So Sherman's arrested. He's unable to post bail. He sits in jail for about 6 months waiting for his trial. On the eve of trial, the judge and the prosecutor are trying to enter into plea negotiations with him. The judge, in fact, offers him a deal. She says, listen, if you plead guilty, I'll let you out today. The guideline sentence, because of his criminal history and the offense, would have called for about 4 years. But she said, I probably won't even give you any prison time because this was not very serious. No one was injured. And Sherman said, no, ma'am, I can't take that deal. I'm actually innocent. So he went to trial. He was convicted at trial. And that same judge sentenced him to 20 years. That's something we talk about. We call it the trial tax, the tax you pay for exercising your constitutional rights, for taking the court's time and doing that. So he was sentenced to 20 years in prison. He was one of the first applications we got. And Sherman was real credible because he said to us, look, I'd been to prison before. I wasn't scared of going to prison. If you look at my record, you'll see I always pled guilty to the crimes I did, but I didn't do this case. So we started investigating the case. We found out that similar burglaries kept happening in the neighborhood after he was incarcerated. Eventually, another man was arrested for those burglaries. We tracked his case. We actually talked to him to see if he'd like to plead guilty to this one as well and admit he did it. He did not want to do that. And we were kind of at a loss, really, for what to do in Sherman's case when I got a letter from this man. His name is David Jones. David Jones was now in prison himself, and he wrote to us and said, I'm in prison with this guy named Sherman Townsend. He didn't do the crime that he's in here for, and I know he didn't because, in fact, I did the crime. And further, David Jones was the neighbor. Okay, so he was the neighbor who identified Sherman, and he did it to save himself. He was, in fact, the person who broke into the house, and one of my favorite exhibits ever was this map that he drew for me to explain what had happened. David Jones was now in prison himself for rape, and it had been his intention to rape the female victim that night. You can see in this drawing, on the left-hand side is his apartment building. On the right-hand side, he drew a 2-story model of the house, the downstairs and the upstairs. His windows overlooked her home, and he had been watching her for a couple of months. And his intent that night was to go over and rape her. And he could give us a lot of details about what he was going to do, that he unscrewed the back porch light bulb. So even though he was going to go in through the window, he knew he'd come out through the door and no one would see him leave. You can see his entry point where he cut the window. And then he was able to tell us things about the inside of our house that we were able to verify with her, actually, that were details no one else could have known. So, for instance, or that weren't known to the police. He said that when he came in through the window, he almost knocked a desk off of the computer off the desk. And you can see the computer desk, and she confirmed that. When he went up the stairs, he didn't know where her bedroom would be. So he opened the first door he saw, which was a closet door. He could tell us that it had hanging clothes rather than being a linen closet. And when he went to the bedroom, the girl and her boyfriend were asleep on a mattress on the floor, not a raised bed. She confirmed that as well. And he tripped when he went to the bedroom on the mattress, fell on the bed, felt the boyfriend's beard, and realized a man was there. He didn't know a man was there. Didn't want to mess with the guy, right? So ran out the door, ran back to his apartment. You can see he drew his little escape route there. And he's looking out the apartment window when the police come, and he is so deluded about what this woman might know about him. He thinks, well, I've been paying attention to her. She must be paying attention to me. Of course, she'll know who I am. So he thought if I go out there and tell them it's a different black guy, they will believe me. And that is exactly what happened. And Sherman was unlucky enough to be getting a pack of cigarettes that night and again have that criminal history. So he was a usual suspect. That's who got arrested. Again, fast forwarding, Sherman was in prison for 10 years when he and David happened to end up in the same prison. David, who was now sober for the first time since he was a teenager, actually had a real crisis of conscience when he reached out to us and was absolutely willing not just to do this map, but to do an affidavit. He eventually came to court, testified under oath, and Sherman was released. So that's an example of a perjury case, but the perjury cases, there are all sorts of different permutations of this. A big area of perjury that we find is jailhouse informants. These are people who are held in a pretrial detention situation with a high value suspect, usually somebody who's in on a rape or a kidnapping or a murder. And all of a sudden this high value suspect confesses to somebody else in the jail that they don't even know. And then this jailhouse informant comes to law enforcement and says, what will you give me if I take the stand and testify he confessed to me? So obviously a very biased situation and real reasons to question their credibility. But that's a discrete area of the perjured testimony, but you can see it can come in all different forms. Another key cause of wrongful convictions is mistaken eyewitness identification. And this is just a slide that can show you some of the problems with identification. Obviously, there's a factor of cross-racial identifications. A significant number of the DNA exonerations involve a white victim misidentifying an African-American suspect. There's been plenty of studies that show, in particular, Caucasians are very bad at identifying people of other races. Weapons focus is an interesting one that people will tend to focus more on. If there's a gun involved in a crime, they'll focus more on the gun than the other things around them. Show-ups I talked about a little bit in Sherman's case. Only one suspect is shown to the victims or witnesses. And then other things that you can think about, the conditions of viewing, how much time has passed, how the suspect and fillers are shown to the witness, and inappropriate fillers that don't look like the suspect, right? There are some very simple fixes that can be proposed that law enforcement can do that will help correct or reduce the occurrence of mistaken eyewitness identification. And I'm very proud to say in our policy area, we just passed a law in Minnesota in May where police officers throughout the state are going to be required to follow these best practices. And these are best practices that have even been adopted by the National Academy of Sciences. The first one is that law enforcement officers should do all lineups using a double-blind method. So most lineups, all of them that I've ever seen, so practicing for 25 years, I've never seen a live lineup conducted in Minnesota. Almost all of them are done through photo arrays. I'm going to show you a couple of photo arrays in a second. But the idea is that the officer conducting the lineup doesn't know who the suspect is in the lineup, so he or she cannot intentionally bias the witness or unintentionally bias the witness. You can see, an officer saying to intentionally bias, is it number 3? Are you sure it's not number 3? Doesn't number 3 look like the description you gave me? But also unintentional biasing that would raise a victim's certainty level by saying something as benign and helpful as that's who we thought it was. We don't want officers doing that because that can increase the witness's certainty level, even though it doesn't increase reliability. Giving instructions to the witness, telling them that they don't have to make a selection, the true perpetrator may not be in the lineup, composing the lineup fairly so that all of the fillers look like the victim's description of the perpetrator, asking the victim or witness how certain they are of their identification, and of course documenting this whole procedure in writing. Law enforcement was voluntarily doing these things through much of the state, but it was not uniform in greater Minnesota. That was part of the reason for this statute. The other problem was that even jurisdictions that said they were doing this were not always doing it. Hennepin County and the Minneapolis Police Department were using these best practices for many, many years, but in 2016, they emailed this lineup to a victim. Email, by the way, so you don't even know the circumstances under which the identification is made, but the victim had said that the perpetrator was a young Hispanic male. This is what was sent to the person in terms of a lineup. There's probably only one young Hispanic male, the gentleman in position number 6. I think the man above him is biracial. Obviously, then you've got a Caucasian young man. I think the man down at number 4 probably looks like John Hamm after he gets a DWI, right? So this is just a completely unfair lineup. Who is the victim supposed to pick but number 6, unless number 6 just looks like nothing like the perpetrator? And this was from Minneapolis in 2016. This is typical of a cross-racial mistaken eyewitness identification. This was a DNA exoneration that I always like to mention because it was done by a county attorney's office. As far as we know, the Ramsey County Attorney's Office, when it was led by Susan Gertner in 2000, was the first county attorney, the first prosecutor in the country to look at her own files to see if she could exonerate, if DNA would prove the innocence of anyone. And there were 3 cases where she wanted to do DNA testing. 2 of them, the evidence was lost or destroyed at the police department when they reorganized their property room. But in the 3rd case, the case of David Sutherland, he was exonerated through DNA testing. Very common of what we see. It was a stranger rape involving a cross-racial mistaken eyewitness identification. The victim was Caucasian and she mistakenly chose David Sutherland. What's very interesting for law enforcement in the DNA cases is once you have the DNA profile and you know it doesn't match the suspect or the person who's incarcerated, it can be uploaded to a national database of felony offenders who have been forced to give their DNA. That happened in this case. And the true perpetrator was this man, a man by the name of O.C. Pankey. So that's very typical of what we see in these cross-racial mistaken eyewitness identification cases. False confessions, as I mentioned, are another common cause of wrongful convictions, particularly in vulnerable populations, although to be sure, many people falsely confess to crimes that they didn't do who don't fall into these vulnerable categories, but we do see it more often in juveniles and the mentally ill. We also see cases where law enforcement is feeding someone information. Any of you who watched Making of a Murderer, the case about Stephen Avery and Brendan Dassey, probably saw how law enforcement was feeding Brendan Dassey information while they were interrogating him about what happened. What's very important as far as innocence projects are concerned, and I think law enforcement in Minnesota agrees with this as well, is that all interrogations are recorded. As they were in the Brendan Dassey case, 2 years before that happened, excuse me for 1 second. The problem of working from home is dogs, right? So in Brendan Dassey's case, had that interrogation taken place 2 years earlier, we would not have had that recording because Wisconsin was not recording interrogations yet. Minnesota does and has recorded interrogations since 1995. And law enforcement actually thinks it's a wonderful tool because people still do confess all the time. From the Innocence Project's perspective, we think it's a wonderful tool because, of course, it has a chilling effect on the worst of law enforcement behavior, and it gives an accurate record of exactly what was said. And it is something that we advocate for around the country and is happening more and more around the country. More jurisdictions are recording these interrogations. This case that I'm going to talk about is not from Minnesota, but I do like to mention it because Damon Thibodeau was actually exonerated out of Louisiana, but the man on his right is an attorney named Steve Kaplan, who's from Minnesota, and Minnesota lawyers have a rich tradition of going into the South and working on capital cases. So Steve was not a criminal defense attorney, he was a tax lawyer, but he was a good lawyer, and he worked with a death penalty organization in the South to get Damon off of death row. Damon had been in prison for 15 years, but not only had he been in prison, the people on death row in Louisiana are kept in solitary confinement. So for those 15 years, he spent 24 hours a day, 4 days a week in a cell. On the other 3 days of the week, he was let out for 1 hour to take a shower, to make his phone calls. But at one point, he told Steve, I just want to die. I want you to quit fighting my case. I can't live like this anymore. Steve convinced him to hang in there. In Damon's case, he had been accused and convicted of sexually assaulting and murdering his cousin. But eventually, DNA testing was done in that case and proved that it was a different perpetrator, someone who was not known to the family at all. Police and prosecutorial misconduct. This is a new report that just came out that is fascinating. It was just released, as you can see, in September of this year. Again, if you go to that exoneration registry, you can review this and see the different forms that police and government misconduct take. Generally for prosecutors and for police as well, it's failing to disclose exculpatory evidence. We do see more police and prosecutor misconduct against African-American suspects, particularly in homicide cases and in drug cases. So I think that's very interesting to know. We have a case of police misconduct here, police and prosecutorial misconduct for failure to disclose in Terry Olson's case. And there was plenty of mistakes to go around in Mr. Olson's case. There was also a perjured witness, and his counsel did a very poor job. But I'll tell you just the brief story of what happened in this case. This, by the way, is Terry with his mom. He was convicted in 2007 for a death that occurred in 1979 that may not have been a homicide at all. The initial investigating officers did not think it was a homicide. Jeff Hamill's body was found in the early morning hours in just outside of Buffalo, Minnesota, when that area was extremely rural. Buffalo was a town surrounded by farming community. Jeff Hamill's body was found by the side of the road. He had been wearing all black, and that's important because ultimately police thought that what had happened was a farmer was moving farming equipment in the middle of the night, which apparently they do to avoid, causing traffic congestion. The farmer was moving the piece of farm equipment. There was probably an appendage sticking out of the farm equipment. The farmer didn't see Jeff Hamill because he was dressed in black. There was a single blow to the back of Jeff Hamill's head that killed him. There were no other injuries to him at all, as a matter of fact, and that single blow killed him, and the farmer went on and didn't know what had happened, never knew he had hit anybody at all. So that's how the case was eventually closed back in the late 70s, early 80s. Police did investigate two parties that had happened in the area, one of which Jeff had been known to be at, that Jeff left that party on foot. They had talked in particular to three guys, Terry Olson, who was our client, a guy by the name of Dale Todd, and another guy by the name of Ron Michaels, but didn't find anything suspicious about what they said at the party. Again, everybody just said Jeff Hamill left on foot at about 2 a.m. But in 2003, Jeff Hamill had an infant daughter when he died. The daughter grew up. She went to law enforcement to find out more about her father's death. And for whatever reason, law enforcement decided to reopen the case and go talk to one of those three guys who was at the party, Dale Todd. At the time, law enforcement knew that Dale Todd was well known to law enforcement as being mentally ill and chemically dependent. They brought him in, they interrogated him for many hours, and they told him a lie. They told him that back in 1979, they had taken a baseball bat from his car, and that baseball bat had his fingerprints on it, Dale Todd's fingerprints, but now through DNA testing, they could prove that Jeff Hamill's blood was on the baseball bat. This was not true, but Dale Todd became very afraid and told this crazy story about driving down the road with his friends, Terry and Ron Michaels, and they saw Jeff Hamill hitchhiking. Terry and Ron told him to pull over. He did not get out of the car. As a matter of fact, he was feeling drunk and he vomited on the side of the road. Police never found any vomit. But Ron and Terry get out of the car, open the trunk of his car, take something out. It must have been the baseball bat, he says. And he doesn't see what happens, but they must have hit Jeff with the baseball bat because they get back in the car and they say, he'll never hitchhike again. Ron Michaels and Terry. So then Dale Todd makes a deal with law enforcement. If he testifies to this against his old friends, Ron and Terry, he will only be faced with an accessory after the fact charge and will just do some short local jail time, will not go to prison. So Ron Michaels goes to trial first. And at Ron Michaels' trial, Dale Todd tearfully admits that he lied to law enforcement because he was scared, that he had nothing to do with it and his friends had nothing to do with it either. Ron Michaels is acquitted, but because Dale Todd did not testify as law enforcement wanted him to, they didn't give him the deal and he was sent to prison. A year later, when Terry comes to trial, now Jeff Hamill is in prison and he comes to Terry's trial and changes his story again and says, what I told law enforcement is true. Terry is convicted. Immediately after he tells that story, Dale Todd writes a letter to the judge and said, I lied again because I was afraid. Nothing happens. Terry stays convicted and contacts us right away. Innocence Project, can you help me? I didn't do this. We start looking into the case. And about 3 or 4 years later, so Terry contacts us. He has his appeal. We don't become involved, I think, until about 2009 or 2010. Dale Todd contacts us. He has his own attorney. He's out of prison. He is no longer chemically addicted, but appropriately medicated for his mental health issues, and gives us a detailed statement about feeling pressured by law enforcement and that nothing ever happened, that Terry didn't do this, Ron didn't do it, and he didn't do it. And he was a very credible witness at this point. He also signed a release for us to get all of his medical records from the prison and from the local county jail where he was being held prior to Terry's trial. And it turns out, unbeknownst to Terry's trial attorney, that Jeff Hamill was hearing voices and seeing things. He was hallucinating. And he also told the jail nurse that he was going to have to lie at Terry's trial because otherwise he was going to get sent to prison for more time. This information was never disclosed to Terry's attorney, even though the nurse who kept meticulous records, bless her heart, told the sheriff this because she didn't think Jeff was capable of testifying. And the sheriff told the prosecutor that, but the prosecutor said, fine, it's no big deal. Well, it's no big deal. We'll put him on the stand and we'll let the jury decide, basically. None of this was disclosed to Terry's attorneys, which obviously would have been a huge deal, right? If he tells a medical professional that he's hallucinating and that he's going to have to lie, but that was never disclosed to Terry's attorneys. Terry's attorneys fumbled in some other ways and made some other errors, but with all of that, we were finally able to get Terry released, and here he is back with his mother 11 years later. So I love these pictures with their moms. They always make me so happy. Ineffective assistance of counsel was not on that bar graph, and I don't really know why they don't put it there because they have a statistic on it, and that is about 27% of cases involved faulty attorneys. Our most recent exoneree, Javon Davis, was a victim of a faulty attorney. It was well known at the time of trial. This was an attempted murder case, a shooting that happened outside of Target Field after Target Field was closed of some employees who were leaving. It was well known Javon had an alibi that honestly I've seen very few that are as good. He was on his cell phone miles away at the exact time of the shooting because they knew when the shooting occurred because it was on video of nearly the exact time that it happened. But he was miles away. That was proven through cell phone records, both tower and data records. But still the jury convicted him because there was some other evidence that was admitted that was mishandled by his trial attorney. It was a video of an interrogation of one of the victims who was shot but lived, who the police were coercing significantly during that interrogation. The prosecutor sought to put that video into evidence when that witness took the stand and said, Javon did not shoot me. I don't want to send an innocent man to prison. The prosecution sought to introduce that video recording. The defense attorney, you probably can't read this, well, maybe you can. The defense attorney did not object to that. And this is the judge saying, well, I guess that must, so the judge is kind of saying that must be your strategy. I'm not quite clear about why you're letting in, but it came in with no objections. So there's nothing for me to rule on, okay? And his attorney said, that's right, and just let the video in. And the video were things that were highly inflammatory about Javon that weren't true. And years later, when we had a hearing on ineffective assistance of counsel to try and get Javon out of prison, his defense attorney admitted that he never actually saw the video. He never actually watched that video. Even though he had it, he never watched it. So that's just one example of the ways that he mishandled this case. Looking at forensic science, we know that in 50% of the first 225 wrongful conviction cases that were overturned with DNA evidence, they involved either unvalidated science or improper use of that science. One of the key players in the game was this guy, a guy by the name of Fred Zane, who was a state trooper at the West Virginia Crime Lab. He testified falsely in at least 5 exoneration cases in West Virginia at the underlying trials of these men who were later exonerated through DNA testing. He testified about blood serology tests implicating them that in fact he never conducted. When his files were looked at after the exonerations, it showed that he engaged in something called dry labbing, that he never actually did the testing. He resigned his post in West Virginia, got a job with a Texas forensic crime lab, and did it again. There's another exoneration out of Texas that came from his caseload. I gotta do that here. The National Academy of Sciences, when reviewing all of the sort of body of work of forensic science, found that really only DNA analysis is truly founded in scientific principles. Many of the other things being relied upon in court are not science at all. They grew up through law enforcement. Law enforcement has been doing these things, but there's no standards, no foundational reliability under the scientific method to believe in these particular things. One final case I want to talk about is based on abusive head trauma or shaken baby syndrome. You can see that in the not science column. In that area, I will say pediatrician and medical examiners are very conflicted about this. This science, and I'm kind of using air quotes, is hotly debated within the medical community. We had a client, Michael Hansen, who was accused and convicted of actually murdering his baby daughter, Avriana. He had been co-sleeping with Avriana. She was 2.5 months old. Her mom was working the overnight shift. When he woke up in the morning, Avriana was unresponsive. He called right away for an ambulance. 911 came. They were never able to revive her. She was taken for an autopsy, and the medical examiner found a large skull fracture in the back of her head, and ultimately went in to testify at Michael's trial that that skull fracture was the cause of her death, and it happened within hours of her death. But there was a well-known cause for that skull fracture. I don't have it. Oh, I got ahead of myself. Oh, okay. So there was a well-known cause for the skull fracture, and that was that she was with her mom at the Walmart in her car seat, and the car seat was perched on top of the shopping cart. Mom came out of the Walmart, hit a pothole, and the whole thing upended, and Avriana fell out. This was well documented because Walmart was afraid of being sued. But Avriana cried for several minutes, but then comforted and was fine. She was never brought to the doctor. This incident happened about 5 days before her death. When we had medical examiners look at this case because we thought there was something wrong with it, we had several medical examiners look at this case. They all ultimately looked at it for free because they said that the medical examiner at trial was absolutely wrong. That skull fracture was at least 3 days old, but could have been as much as 2 weeks old because you can tell from iron staining that happens through the healing process. Also, very importantly, babies don't die from skull fractures alone. What this slide illustrates is that really what you won't die from a broken bone. You need to have underlying brain bleeding or brain swelling, and neither of those things had occurred in Avriana's case. In fact, what had happened is she died of SIDS, positional asphyxiation, or the inability to sleep, to breathe in her sleep. And with that, I have this picture of Mike where he is finally reunited with his mom. I think the bottom is cut off, but he served 6 years of his sentence before being reunited. And that's it. So I'm going to stop sharing my screen, and we have a few minutes left for questions. Okay, there.
Wow.
Yeah.
Go ahead.
Yeah, it's a lot. I know it's a lot to do in like a half hour, like, whoa. Thomas?
Yeah, Thomas. First of all, Julie, thank you so much for that. That was really a fantastic presentation. We have a friend that has worked with the Innocence Project. I can't remember which state because she's worked in New York.
Can you speak up just a little bit? I don't know if others are having trouble hearing you too,
Oh.
if it's just me.
Okay.
That's much better. Thank you.
I'll speak louder and closer to the mic.
Thanks.
Anyway, thank you so much. I'm curious about the use of lie detectors because, so in my field, I work in brain imaging. It's basically been shown that lie detecting is incredibly inconsistent and easy, well, maybe not easy to beat, but it's beatable for sure. And there's lots of false positive, false negatives.
Yes.
Is that something that's used ever as well? I just didn't see it on your list of ballots.
No, so in fact, so most courts throughout the country do not admit lie detector tests, okay? So it's not, everybody's aware of that. There are some interesting stories in the false confession cases of the police doing a fake lie detector to a suspect and telling them that they failed, right, as a way of getting them to confess. So I've heard that. I have heard of some defense attorneys, and this is a practice, even though it's not admissible in court, some defense attorneys will have their client undergo a lie detector test to present it to the prosecutor as sort of a piece of proof of why the guy is actually innocent, but that would not be admissible in court.
Got it, thanks.
Julie, I thought that was amazing. I'm so fascinated with this whole
Thanks,
line
Eric.
of work. What is the role or the responsibility of the Innocence Project once someone has been had their conviction overturned, especially for like people who are convicted when they're 18, 19 years old, have no credit, have no job skills, or, once that conviction's overturned, what's next for them?
Yeah, so we do have some volunteers who help us with that. I've got a couple of therapists who have volunteered to do therapy with our clients, which I think is really important. We've been incredibly lucky, and the men that we've gotten out here in Minnesota have all had family to go to. So, many of them were convicted very young, were in for long periods of time, but they had family to go to for a while, at least, to get on their feet. We have volunteers who will help them go to the DMV and get their driver's licenses back. We try and hook them up with job training through Goodwill or, whatever they have. There's Twin Cities Rise is another job training program. I've got one retired woman who was working with me who was a former reentry counselor for the Department of Corrections. So she has a lot of resources. So we have this sort of network of volunteers who help us with those things. We also, with GoFundMe, they've been able to get a little bit of money through GoFundMe that can kind of help get people started. At the larger innocence projects that have like many exonerees in their community, Texas, New York, California, they actually have social workers on staff that help these guys, and it's a full-time job. We don't obviously have the numbers. We have like 7 people that we've gotten out, and we get like one out about every other year, so we don't have the numbers to justify that. But Innocence are such great people that we have some really good, talented, experienced volunteers who bring real resources from their own jobs to help these guys.
Julie, how are you funded for the work that you do? And I mean, how do you choose which cases to take on? And is the caseload way larger than your staff can support?
Yeah.
Or
so for many, many years, I was the only attorney employed by the project. We used a lot of services from pro bono attorneys, but we got a very large foundation grant 2 years ago that allowed us to hire 2 more attorneys and expand our services into North and South Dakota. So next year, we're going to have a new name. We're going to be the Great North Innocence Project. The branding is in play, is being done right now. But most of our fundraising before this large grant came through law firms. We had a gala every year. This year it was a virtual gala where law firms bought tables. We had a silent auction and a live auction component. We brought in a national speaker, and that was really the vast majority of our fundraising. Not a great model, right? Because you want to have a diversified fundraising model, which we do have more. We are getting more foundation grants, more individual grants. So it's nonprofit, largely law firm based, but more and more we're getting more foundation and individual grants, and some government grants too. We just got a grant through the DOJ, Department of Justice, to do a conviction integrity review unit with the Attorney General's office. So this would be situated in the prosecutor's office. They have a ton of power in these cases, right? They have all the power in these cases, and there's a lot of procedural hurdles. For every one of these cases, there's several that we couldn't help because of procedural hurdles. The prosecutors, if they believe in someone's innocence, can agree with us to overcome those procedural or ignore those procedural barriers because of proof of innocence. So we just got a good grant to do that with Keith Ellison's office that I'm really excited about. Picking cases is really kind of my job. The vast majority of my time, I do this stuff and I do policy work, but I do spend a lot of time screening cases. Obviously, we get a lot of requests from people who aren't innocent, right? And trying to figure out who is and who isn't, and making sure we do our due diligence. Even, because when somebody's convicted, they may look really guilty, but then you can uncover evidence that perhaps police didn't find or they ignored. That is proof of innocence, right? So I do a lot of that work with law students at the University of Minnesota and Mitchell Hamlin School of Law. We do all of the case screening for Minnesota, and then they do some investigations as well, tracking down witnesses, talking to witnesses, locating evidence. And then we also, if it's a sensitive case or a dangerous case, we'll hire a private investigator to do that kind of work. But it's sort of a pyramid, right? So we have at the bottom of the pyramid hundreds of requests for assistance. Then a certain number make it to screening where the students work on it, and then to investigation where it might be students and an investigator, and only a very, very small amount will go to litigation. And that will either be led by myself or one of the staff attorneys, and then oftentimes partnering with a large law firm.
So how many cases do you work on concurrently?
Well, so when it was just me, I typically had between 30 and 50 open. Now that we've got North and South Dakota and 2 more attorneys, we've got, I think right now, about 85 open. So in different stages. Some are in litigation. We probably have 10 cases in litigation. I probably have 40 out with students right now in screening and investigation. And my co-staff also have, you know, probably 15 or 20 each. Well, if that's it.
Are there any other questions?
I did have one more question. You mentioned you had a big win this May with the law passed when it came to lineups. Do you just see the numbers, and obviously there's something not right? You know, there's this many people wrongfully convicted. So what are some other things that you're working on from a legal side, or in policy?
Yeah.
Kind of what are the big things that you're going after to
So-
help prevent some of this?
Yeah, so that we've gotten in Minnesota now, we're kind of doing already the 2 easy fixes, right? We record custodial interrogations, which I talked about, and we've got law enforcement will be following best practices for lineups. The next big area we want to work on is jailhouse informants, and I talked about them briefly in the perjury area. People who are incentivized to testify, they don't know anything about the crime, but they're given some sort of incentive, a reduction in sentence, or even money, or complete release from prison, or dismissed charges in exchange for testifying. This is a very murky area, and a lot of times those deals aren't disclosed to the jury. Their prior criminal history might not be disclosed to the jury, whether they were a snitch or a jailhouse informant in other cases may not be disclosed to the jury. We think all of that should be disclosed to the jury. So we would like a law saying, prosecutors, if you're going to use these guys, the jury needs to be made aware of all the warrants, right? And maybe the judge could even do a limiting instruction saying that this type of testimony is shown to be not reliable. So we're going to be working in that area next.
Thank you.
Thanks.
Any other questions? This is fascinating. I think we could probably talk for much, much longer. I can't help but say there's the movie Mercy that was out not too long ago that was akin to this, a story of somebody who was wrongfully convicted in the South. And if you haven't had a chance to see it, watch it.
Yeah, it's amazing. It's based on Brian Stevenson's book, Just Mercy, and it's incredible. He's like my hero. He's so wonderful. Everything you see about him in the movie is true, and then some. I mean, he really is a hero of all of this. And I see, Betsy, I'm not very good at looking at the chat while I'm talking, but thank you for putting that up. If you guys are interested, there's a link to the Exoneration Registry right there. They've got a great sortable list that you can look at the different, I'm kind of a geek on this, so maybe you won't be that interested, but you can look at the different causes, and then you can click into each individual story to find out kind of the background, like I've just told you here on several of these.
Wow. Amazing. Well, I think we have definitely all learned some more, and as there's a lot of attention in the community about policing, the wiser and more informed we can all be, the better, for certain. Thank you, Julie. Thank you so much.
Thank you. Thank you. I'm gonna leave you guys now. Enjoy the rest of your meeting and your day. Bye-bye.
Here, bye-bye. Okay, and for closing here, we are going to recite the 4-way test of the things that we think, say, and do. First, is it the truth? Second, is it fair to all concerned? Third, will it build goodwill and better friendships? Fourth, will it be beneficial to all concerned? That concludes today's Golden Valley Rotary Club meeting. Nice to see you all. Get outside and enjoy this beautiful weather. Thank you, everyone.